Hello everyone, so today we're talking about governance issues in professional sport. Governance of professional sport is roughly divided into governance of team sports by professional sports leagues and governance of individual sports by players' associations that operate the professional tours. The chapter first provides an overview of antitrust law as a foundation. It examines the governance issues pertinent to the authority of professional sports leagues, which includes the power of the commissioner, the legal structure of leagues, applications for sports franchises, the team ownership, franchise relocation, rival leagues, and equipment regulation. The chapter then goes into examining governance issues related to individual professional sports, including organizational structure of tour players associations, control of events, equipment regulation, and disciplinary authority. Legal issues with respect to the governance of professional sport include contract law, labor law, the law of private associations, and limits on owners imposed by federal antitrust law. So as you can see, most of the laws that we'll be talking about today in regards to sport league governance and individual sport tour governance are governed by the Sherman Act. Now, with overview of governance and structure, there are different types of organizational structures that attempt to reduce exposure to antitrust liability. With the professional sports leagues, that typically is governed by the commissioner. We're going to talk a little bit more about that later, but the commissioner, then you have a board of governors or owners committee, and then you've got the centralized league office. And then looking at the professional individual sports side, typically it's governed by the players' associations. Now, the power of the commissioner. Most professional team sports are structured as a league that is governed by three bureaucratic layers: the commissioner, the league's board of governors or owners committee, and the centralized league office, as we just talked about. The commissioner's power is defined in the league's constitution and bylaws. Now, the owners have the authority to hire and fire the commissioner, but the commissioner has the authority to impose disciplinary measure on the owners, so it gives him a little bit of power. But there is some balance there as well. So the commissioner's areas of decision making include approval of player contracts, rulemaking, dispute resolution, and disciplinary matters. Now, it does restrain excessive exercise of owners' powers, which could be detrimental to the fans. The commissioner also serves as a lead negotiator for league-wide contracts such as TV deals and negotiator for the owners and labor disputes with players' associations. League bylaws grant commissioners discretion to act in the best interests of the game. Now, there are some constraints on their decision making. They must act within the scope of their defined authority, as well as acting in good faith. And there should be some tenets of procedural fairness and consistency. So making sure that you are ruling fairly in comparison to other issues of the same matter. And that there is no violation of any state or federal law. Now, courts will not necessarily interfere with a commissioner's authority to act in the best interest of the game as long as his actions fall within the constraints of a league's constitution and bylaws, the collective bargaining agreements, and due process. Now, the overview of antitrust and Sherman Antitrust Act. The purpose of these antitrust laws is to promote and protect the operation of free market capitalism, with the resulting benefit to consumers of better products at lower prices. So, in Section 1, the Antitrust Law, Sherman Antitrust Act, prohibits concerted action, which is joint action between two or more parties, from restraining trade in a relevant market. The relevant market is the economic market in which the defendant's business operates. So in the same market, more or less. Section 2 prohibits predatory or exclusionary conduct enabling an organization to acquire or maintain monopoly power in a relevant market. So with this, professional sports challenge, they have a challenge with the traditional application of antitrust law with businesses. It's very different. And so with professional sports, they have to be economically competitive. And with conventional businesses, there's an economic interest in putting rival companies out of business. But professional sports teams have an interest in not competing too strongly economically with their rival teams. They must attract and retain consumers so that the leagues maintain competitive balance across the league, across the teams, so that the outcomes of the games are contested and uncertain. So you want to maintain some means of competitiveness there, but not anything that's overbalancing. So maintaining competitive balance allows for certain uncertain outcomes, and it also maximizes your entertainment value. Now, the structures of pro sport leagues. The pro sport leagues have traditionally been structured as a nonprofit, incorporated, or unincorporated association of clubs where each member club has separate and independent ownership. Different sports have differing rules regarding club ownership. The traditional structure is that an association of clubs, they each have separate and independent ownership. Now, with that, there is a primary advantage, and the promise of that is profit-making potential for individuals who want to make an ownership investment and incentive. It provides those owners so that they can maximize the value of their team. Now, sharing league-wide revenues links the individual owner's interest to their general welfare of the league. Primary disadvantage to the traditional structure is that necessary agreements among owners for the good of the league as a whole subject the league to potential liability under the antitrust laws for entering into agreements that unreasonably restrain free trade under Section 1 of the Sherman Act. Now, a single entity structure offers league-generated entertainment product rather than a collection of individual entities in economic competition with one another. Here you see Major League Soccer, Arena Football League, and formerly the Women's National Basketball Association. Now, the WNBA have actually returned to a traditional model of individual ownership, really to create stability independent of the NBA's support structure. All players are employees of the league and not a specific team, which allows for better control over costs for the new leagues and over player salaries. The single entity status does protect them from review under other antitrust laws, so it does give them some protection there. There is an application for sport franchise, and we talk a little bit about that in another slide. But professional sports leagues have rules governing a team's application for a franchise within the league. So with that, the division of responsibilities in a traditional league structure, the league office conducts operations such as scheduling the games, hiring and training officials, disciplining players, marketing licensed logo merchandise, and negotiating broadcasting contracts. The league board of directors or owners committee tends to oversee policy making on issues such as franchise relocation, league expansion or contraction, playing facility issues, collective bargaining, rules of play, and revenue sharing, or non-locally generated revenue. Whereas the individual teams have responsibility for facility acquisition or leasing, team marketing, ticket sales and luxury seating, and also the arrangements for local broadcasting contracts. Now, team owners, again, they have leagues. The leagues have rules that set eligibility standards for acceptable owners. With the MLB, or Major League Baseball, they have no formal criteria, but they do consider commitment to the local franchise area, the amount of financial capital, and ownership structure that possesses no conflicts with the interests of the league. So really, they want to make sure that someone has the capability, the financial capability, and business sense to put a team together and to be able to maintain that stability with the team. Now, the NFL has a restrictive ownership requirement. It prohibits public ownership of a franchise. Now, the Green Bay Packers were actually at one time publicly owned and they are publicly owned and were grandfathered in as a team. It also prohibits corporate ownership of a franchise, such as the San Francisco 49ers, and they went through some of their battles with that as well. The main concern with team ownership is they want to be very careful in cross ownership, which is ownership of more than one sports franchise. With that, the cross ownership ban, really what they found with that, the whole idea with the cross ownership is someone who owns one team in one league and another team in another league. You want to be careful with that cross ownership, and so there were restrictions with that. There have been court cases where they have found that actually the cross ownership ban restricted free trade, and so there have been some spinoffs from that. And there's also the transfer of ownership that is a concern with team ownership, and they must provide adequate financial capital, character, sufficient business skills. So this is when someone else is, they're transferring ownership to another person, and they just want to make sure that that other person has adequate financial capabilities, is of good character, and has good business skills. And what they're wanting to do is make sure to enhance the interbrand competition, meaning the ability to compete with other types of sports entertainment offerings by preserving the quality of the league's product. So they realize that there's a lot of competition for sports entertainment. You've got basketball, football, hockey, and even looking at not just professional, but also community stuff that's going on. So they just want to make sure that the league is going to be taken care of, the team is going to be taken care of, and yeah. Now, in your opinion, what should be the ramifications to the owner of a team who has made racist remarks about players and fans? This is actually a discussion that we're going to be talking about this week. And what action, if any, should the league's commissioner take? Now, with franchise relocation, occasionally franchise is not working very well in one city, they want to move to another city. There are franchise rights that team owners include, and they're called territorial rights. This basically prevents a franchise from relocating into a competitor team's market territory without league permission and adequate compensation for the potential loss of market. It does require a 3/4 vote of the owners or majority vote of the Board of Governors. Typical justifications on franchise relocations include the following restrictions. Sites must have sufficient characteristics to maintain league stability. Relocation must not negatively affect team travel and scheduling. The new territory does not encroach on existing territorial rights. And the relocation does not reduce geographic diversity. And the relocation honors contractual and ethical duties. Now, cities must protect its investment in professional sports franchise and encourage a team to stay. And so to do that, oftentimes they will include a liquidated damages clause in a facility lease contract that would require a team to pay several $1 million to the city if it breaches the lease agreement by relocating somewhere. You actually see some of that franchise relocation going on right now in San Diego, and looking at another football team. I don't know how it can support another football team, but anyway, that's some of the negotiations that are going on currently. Now, thwarting rival leagues, there are some things that existing leagues can do to take steps to preserve their market position that risk violating antitrust law. They can use cross-ownership rules to limit initial investment capital, meaning the cross-ownership ban, again, was anti-competitive and it prevented teams from competing effectively with another league for spectators and TV revenue. So they can limit that initial investment capital by using the cross-ownership rules. They also restrict the supply of players. So they use the reserve clause in player contract functions to give teams a perpetual right to keep their players unless they're traded or released. With that, they created a possible illegal monopolization effort, restricting the available pool of capable players. So you can restrict the supply of your players. To limit media exposure, that can be something that can definitely be a hindrance to a rival league. And limit the availability of sites. And this is through Section 2 of the Sherman Act. It prohibits predatory or anti-competitive conduct designed to enable the willful acquisition or maintenance of monopoly power in a relevant market. The relevant geographic market in which franchises could be established can be proven, and that they are not limited to a local geographic area, but they are actually nationwide, and so it kind of changes the dynamic there. An entity that has a natural monopoly power because of the success of its business is allowed to enjoy and build on that power unless it misuses that power to further its monopoly. Now, there are some exclusive facility leases, and that's another means of restricting playing sites. Refusing to share a facility that would be economically unfeasible for a would-be competitor to duplicate, constituting a severe impediment to prospective market entrance, and that creates an unreasonable restraint of trade. As well, there are some also exclusive contracts with equipment suppliers that adversely affect competition in a broad market and uphold contracts. Now, to create a competitive advantage strategy while working within antitrust law, first ask an attorney to help define who the relevant market is, what the relevant market is. Then seek help in weighing anti-competitive versus pro-competitive effects of rules on economic competitiveness. Then try to predict how a court would decide your case if the rule were challenged under law. So you kind of work backwards. You think about how the court would decide your case and try to work out all of those kinks. Now, as far as the structure of professional individual sports, it's very different from the traditional structure of professional team sports. Athletes in individual sports are not employees, and they are not subject to employment discrimination, labor laws, or antitrust laws. They are really their own entity. They are considered to be touring pros or contestants with the right to be protected from discrimination and access to tournament play under the place of public accommodations, provisions, and several civil rights statutes. You saw this a few years ago where Michelle Wie was trying to, she felt like she was being discriminated from the Professional Golf Association. Of course, it's Men's Professional Golf Association. She was wanting to break into the Men's Professional Golf Association, feeling like the women were not as competitive as they needed to be, and eventually it was knocked down. She was not allowed to play in the men's tournament and had to continue playing in the women's tournament. The organizational structure for individual sports, it typically is by events or tours, and it is governed by players' associations. Now, the players' associations actually includes active players and other stakeholders. Now, the individual sport athletes don't necessarily earn a salary. Instead, they win prize money. And some examples, of course, Professional Golf Association Tour, the Women's Tennis Association. So who controls the events? Within an individual event, the owner or producer or promoter is entitled to all of the revenue unless there is an agreement to share it with other entities. Contractual agreements for concessional revenues are shared with the facility owner, or parking revenues are shared with the host city typically. When an event is part of an organized tour, the promoter may have to surrender some control, such as the revenue generating processes, to Players Association or to the tour itself. Typically, Players Associations may officially sanction, which means they recognize certain events over others. And then the event producer retains significant responsibilities for staging the event, such as procuring equipment, arranging for parking and transportation to the venue, providing security systems and personnel, arranging for concession services, and handling operations during the event. As far as regulation of the equipment, most of these are governed by, most sports have rules specifying what counts as acceptable equipment and what is illegal. So with that, exclusive contracts with equipment companies, do they necessarily constitute a monopoly? Are there rules that prohibit certain equipment as unreasonable fair trade, restraint of trade? And what technological developments are acceptable, as well as what technological changes alter the game too much. So you have to look at the regulation of equipment as well as the rules, how some rules have changed. The three-point rule is one that changed the game of basketball. And it wasn't necessarily related to equipment, but it was related to the facility. So instituting that three-point rule and the line on the court did an awful lot for the game of basketball. Really changed the dynamic, making it a little more dynamic. How do you feel about technological changes to equipment and thus to a sport? Can you think of examples of changes that have changed a sport for the better? What about for the worse? So looking at disciplinary authority, because active athletes serve on Players Association, they do have influence in shaping governance policies. They are also in a position to make disciplinary decisions that affect their fellow competitors. Professional sports athletes serve on executive boards of their Players Association, so they have an influential voice in shaping governance policies, including provisions establishing disciplinary procedures. Now, with competitive advantage strategies for governance of professional individual sports, you want to consider a variety of potential legal challenges when making decisions about rules to control your event. Exercise foresight in decision-making. Identify strong, legitimate policy reasons to support regulation of specific equipment. And ask your lawyer for opinions on how antitrust law might apply to your sports activities. Find a way to avoid having active athletes subjectively impose sanctions on fellow competitors. So, if you were to become a professional athlete and you had the needed skills for any sport, would you prefer to be involved with a team sport, such as basketball, or with an individual sport, such as tennis? Why? And so I look forward to hearing your answers to those questions and our discussions. Remember, make sure to bring in relevant material from the text as well as from your other resources. You guys have the internet. You can check out your favorite internet resources and make sure that you're posting it with your discussions. All right, you guys have a great day today.